Let's see. Is everyone here? There's 61 participants. Is that right?
People answer.
62?
Yes, Kendall.
Yes, I think it's there are a lot of people here. We can start now.
Okay.
Start, Kendall. That's what happens when we have a superstar.
Yeah. I think we have 55 with us now.
Okay. All right. So if you want me to start, I'll start. Okay. Hello, everyone.
Yeah.
And it's my understanding this is the first of the seminars in this series, Teoria do Direito em Tempos de Crise. And I speak Portuguese, infelizmente. So I'm going to make my remarks in English. And the title of my remarks is From Diversity to Development. I want to talk about the diversity idea, which is one of the central conceptual pillars in that part of US public law, both principally constitutional law, that we here call affirmative action, and that you call sois afirmativa. The diversity idea is absolutely central to the way that we lawyers and more generally lay people think and talk about the questions, the policy questions that are encapsulated within the rubric of affirmative action. And the reason I chose this topic is because it's obviously relevant to you. I believe you have now over a decade of experience in the Brazilian context with affirmative action, or as you all sometimes call it, quotas. We don't have quotas here, but we do have affirmative action policies. This is from a report by the Brazilian Institute of Geography and Statistics from late last year entitled Social Inequalities by Color or Race, in which the report notes that in 2018 in Brazil, Black and brown people became 50.3% of the students in institutions of public higher education in Brazil. That is, of course, much higher than is the case in the United States. And what's really interesting is that that percentage, 50.3%, more or less roughly reflects the percentage of Black and brown people in the Brazilian population. There are some points of convergence, notwithstanding the differences between the US and the United States with respect to the question of diversity, which has also been taken up in the Brazilian context. So I believe you had, I don't know whether on the current presidential administration, you still have a minister in charge of inequality, inclusion, and diversity, diversidade. I don't know the genealogy or the history in the Brazilian context of when these specific concepts became part of your national discourse around affirmative action. But it is a point, a discursive point, data point, that I think provides a platform for I don't know the genealogy I want to make about why, from the viewpoint of legal theory, the notion of diversity should be interrogated and perhaps even rejected in favor of what I'm calling development. Now, in US jurisprudence, and we can pinpoint its emergence to the year 1978 in an opinion written by a member of the United States Supreme Court in a case called Regents of the University of California versus Bakke. The Bakke case involved a challenge to the affirmative action program, which was a quota program, at the University of California, Davis, a public state university. And the program was challenged both on constitutional and statutory grounds. The court, however, if I remember correctly, and I'm not claiming to, but the court, as I recall, limited its opinion to the constitutional question of whether or not the 14th Amendment to the US Constitution permitted the University of California at Davis Medical School to admit persons on the basis of race, or to use race as a factor for determining whether or not an individual should or should not be admitted to the University of California Medical School in Davis on the basis of race. And Powell had a few things to say about this question, but he began with a certain skepticism about the meaning, the very social meaning, if you will, of the idea of race. And for the words black and white, or black and Chicano or Latino, or Asian and white, he substituted these terms majority and minority because he wanted to argue that this was an instance in which a minority was being given something called a racial preference. And the fact that Black and brown people in 1978 were minorities was, on his view, not something that would be fixed for all time. That's certainly true. In fact, we are in the United States well on the way to becoming a majority-minority country. Right? There are some states already where people of color are a majority of the population. Powell argued in his opinion, which was not the opinion of the court, but a plurality opinion for 4 of the 9 members of the Supreme Court, that the concepts of majority and minority necessarily reflect temporary arrangements and political judgments. The white majority itself is composed of various minority groups, most of which can lay claim to a history of prior discrimination at the hands of the state and from private individuals. Not all of these groups can receive preferential treatment, and corresponding judicial tolerance of distinctions drawn in terms of race and nationality. For then, the only majority left would be a new minority of white Anglo-Saxon Protestants. So here you have Justice Lewis F. Powell, a white man who was born in and lived most of his life in the state of Virginia, which was a member of the Confederacy of Southern states that fought to preserve slavery, reducing the question of racial power and racial inequality in the United States in 1978 to a question of numbers, right? And these free-floating categories of majority and minority. In effect, he deracinated, I love that word, he deracinated and emptied this question of whether or not it was proper in the pursuit of racial justice to adopt and pursue affirmative action policies to a question of mere numbers. Powell, however, did agree with the petitioner, the University of California, Davis, that it might be permissible under the US Constitution for the University of California of Davis to have an affirmative action program, not to prefer individuals on the basis of race, qua individuals, but to attain a diverse student body. And he spelled out a number of reasons why diversity was a good thing in the context of higher education, and said that it could be taken into account as one element in a range of factors that the university could consider in its pursuit of a diverse or heterogeneous student body. Right? Now, this has been the dominant framework in US constitutional law since 1978 for legal arguments about the propriety or impropriety in particular cases of affirmative action. But that's not the principal point I want to make, because constitutionalism, of course, is not just a question of law, it's also a practice of politics, right? So the trouble with diversity, I want to put to you, in the American context, and you can decide how much this resonates with your experience of the Brazilian context, has to do with the limits of liberal legalism, both on its own terms and as a way of framing the social problem to which constitutional law seeks to respond. All right, so we can say a number of things about the problems with liberal legalism and the diversity argument that liberal legalism of the kind to which Powell subscribed belong. One, it's procedural, formal. Second, it's statist or nationalist. It looks at the question from the point of view of the state, rather than from the point of view of civil society. It's individualist in that it sees a concern with and attention to the situation of groups as a deviation from an otherwise individualist norm, and to focus on constitutional rights as personal individual rights, rather than rights that belong to groups, and more fundamentally, of constitutional harms as harms that are both perpetrated by and committed against individuals rather than groups. Finally, and perhaps most importantly, diversity as an instance of what I've been calling liberal legalism is post-ideological. And by that, I simply mean to capture that line of argument in which the ideology of race, in effect, disappears from the court's constitutional analysis. And Justice Powell focuses simply on the question of whether it's right for a majority under the 14th Amendment to the US Constitution to adopt policies and practices that accord a preference with respect to a public good, here, university education, to minorities. My friend, Charles R. Lawrence, who teaches at the University of Hawaii, pointed out, and I think this is a very useful insight, that liberal legalism of the sort I've been talking about in the United States wants to associate the law with science, right? With the science of law. And this has to do in part with the ways in which legal education and legal practice are in conversation, and has to do as well with the way in which in the modern period, the common law method that its reliance on deductive reasoning and its obsession with fact and empirical evidence, right, are efforts to use and ground law and the legitimacy of law in science, right? Let's see. I'm gonna just since I can't see my screen. Hold on just a moment. And I'm gonna go to my other computer because I want to be able to read what I've written on the slide. So bear with me, please. Paraná. Yes, here we are. Slideshow. Yes. The perceived roles of ideology and interest politics as driving forces in the affirmative action debate have amplified the authority of empirical evidence. But I want to focus on that first claim. The appeal to science is a powerful tool in the political and legal discourse about race. So, you know, the law wants to be a science. Okay, so we have a problem here. Yes. Now, Lawrence goes on to say, the case for diversity is a case for the integration of a privileged class, because the liberal defense of affirmative action accepts the reproduction of elites as the primary purpose of selective colleges and universities. It neither questions the validity of standard admissions criteria used at these institutions, nor examines the ways that these criteria reinforce the effects of societal segregation and racism. And so the point here that Lawrence is trying to make is that certainly at universities, like the University of California, like my own university, Columbia University, or like Harvard University, which is right now actually in the midst of what may be a decisive litigation around its affirmative action program, which Powell, by the way, and Bakke pointed to as an example of good affirmative action, right? Policies. Affirmative action is understood to be about the reproduction of elites. Indeed, in 2003, Justice Sandra Day O'Connor, in a case called Grutter versus Bollinger, said that one of the reasons we value diversity is because we want to make sure that for purposes of democratic legitimacy, every social group has access to these important public goods and resources: law degrees, medical degrees, engineering degrees, philosophy degrees, and the like. But what's not questioned is the reliance in the United States on the standard admission criteria, which are basically twofold. One, your grade point average as a student, and two, your test scores on standardized tests, which are administered. They're basically multiple choice tests. the important point I want to make, though, is that diversity and the reliance on diversity as an alternative framework to a theory of affirmative action as compensatory justice, right? As a remedy for past and present discrimination is an instance of adaptive discrimination, or what Riva Siegel of Yale Law School calls preservation through transformation, right? Because the way it's operated is a small group of people from each of these racial ethnic groups, Latinos and African Americans, Native Americans, and others, are admitted into these elite institutions. But the fundamental baseline, which holds that access and admission to these opportunities are a function of merit, right? As determined by grade point average and your test scores on these so-called objective multiple choice tests, none of that is challenged. And we don't ask larger questions about whether these public institutions, and by public institutions, I mean even private institutions like Columbia University and Harvard University, which receive a lot of public funds, whether these institutions should more fairly reflect the way the United States looks, the actual demographics of the United States right now. Another way to put this is to say that the diversity paradigm is an instance of what the scholar Laura Beebe calls hermeneutical injustice. And she defines hermeneutical injustice as in the following terms. She says, hermeneutical injustice is a situation of those who realize that some significant area of one's social experience is obscured from collective understanding. So I want to go further and say that the hermeneutical injustice of the diversity paradigm is better characterized as a kind of symbolic violence along the lines that Pierre Bourdieu describes in his work, in that everybody now talks within the language of diversity. Diversity is the dominant discourse for talking about issues of racial equity and inclusion. You can no longer, in fact, talk about affirmative action as a remedy for past and current discrimination because of the additional feature, which I want to mention now, of modern equal protection law under the US Constitution, namely that the court has defined the denial of equal protection that is prohibited by the 14th Amendment, the denial of equality that is prohibited by the 14th Amendment as a discrimination, right? And has defined discrimination in very narrow terms to include only the intentional, purposeful, deliberate, right, act of denying an individual or disadvantaging an individual because of that person's race, right? And so the combined force of this really narrow, crabbed conception of discrimination, which leaves the whole question of structural racism off the table, plus the diversity paradigm, and the demand that advocates for people of color seeking to address the situation of vulnerable racial publics fit their arguments within these existing legal categories is a kind of hermeneutical injustice in which, as Bourdieu would put it, Black and brown people and their advocates are made to be complicit in their own subordination, right? I hope you see the point I'm trying to make, right? And that's a sense in which the diversity, you can't win for the diversity game, and you can't lose, right? It's a kind of catch-22, right? You're damned if you do, and you're damned if you don't, right? And so it preserves the subordination of people of color precisely under the rubric of a legal discourse and doctrine that claims to be adequate to the task of identifying the problem of the denial of equal protection of the laws. So we could say that the rhetorical strategies that are being deployed through this narrow idea of discrimination and through the language of diversity may change, right? But the discriminatory practice with which I'm concerned, namely structural racism, remains constant. And so what would a legal theory look like that can get at this problem of structural racism and get around the obstacles to understanding the social experience of Black and brown people in the United States, that the existence and use of the diversity and the discrimination paradigms represents. All right. So I want to suggest that what we need to do is move from a constitutional rights focus on discrimination and diversity as the remedy for discrimination that the court has said you can only even seek to remedy if it's intentional, right? So the disparate impact of these so-called meritocratic policies of admitting people solely on the basis of their grade point averages and their tests on these scores, right? How do we get to an understanding of the ways in which the continued disparate impact of these so-called race-neutral policies, GPA, and so-called objective tests perpetuates the subordination of Black and brown people in ways with which we ought to be concerned if we subscribe to a deep theory and a deep understanding of what racial justice and racial injustice are about. Well, I want to suggest that we move from a constitutional rights to a human rights perspective, and from a focus on the discourse of discrimination, diversity, and inclusion to a discourse of development. And here I draw on the work of my late colleague, Professor Manning Marable, the eminent historian who in the early 80s wrote a book called How Capitalism Developed Black America. So notice the move I'm making from constitutional rights to political economy, or the centering of political economy as relevant to thinking about constitutional or democratic justice. Marable wrote in 1983 that the most striking fact about American economic and political history, politics, is the brutal and systematic underdevelopment of Black people. He's drawing here on the work of the late, great Ghanaian scholar, Walter Rodney, who wrote a book called How Europe Underdeveloped Africa. Manning goes on to say, African Americans have been on the other side of one of the most remarkable and rapid accumulations of capital seen anywhere in human history in the United States. And yet, he goes on to say, this relationship is filled with paradoxes. Every advance in white freedom is purchased by Black enslavement. White affluence coexists with Black poverty. White state and corporate power is a product in part of Black powerlessness. Income mobility for the few is rooted in income stasis for the many. white society has systematically excluded Blacks as a group, not just as individuals, but as a group from the material, political, and gains achieved by other ethnic minorities. Blacks are unemployed, economically exploited, and politically disenfranchised, not in spite of the fact, but because they are excluded or segregated because of caste or racial discrimination, right? And he goes on to say that one reason Black people in the United States occupy the lowest rung in the ladder of American upward mobility is because they have been integrated all too well into the system. That is to say, American democracy as such and the so-called free enterprise system of free market capitalism as such are structured specifically to maximize Black oppression. In other words, capitalist development has occurred in the United States not in spite of the exclusion of Blacks, but because of the brutal exploitation of Blacks as workers and consumers. Blacks have never been equal partners in the American social contract because the legal and economic system of the United States exists not to develop, but to underdevelop Black people. This is a remarkable and radical claim, which liberal legalism, with its focus on individuals and on this idea that racial discrimination is episodic and not systemic and occurs in interactions between individuals, it has no way of thinking this question of structural racism as methodology of underdevelopment. Right? So what would it mean to see American racial democracy as a regime of racialized underdevelopment, or to reclaim and reframe the human rights paradigm? I had two examples. One was the case of literacy and education. I thought, given the current situation, I would focus very briefly in closing on COVID, to understand the truth of this insight of the ways in which American society, politics, and economy have been structured not to develop it, but to underdevelop Black people, even as it is extracting labor and wealth from them, right? So the slaves, the slavery of the time of my forebears has become, in the age of COVID, the age of the so-called, the phrase we've been using, essential workers, right? So the people working in the hospitals, the people delivering from Amazon, the people working in the grocery stores here in New York, but throughout the country are disproportionately people of color, right? So the extraction of labor, the compulsory labor, because like Black and brown people in Brazil, most Black and brown people in the United States, or a very small number of the people who have the luxury of sheltering as we currently are at home, are Black and brown, right? This kind of work, this intellectual labor that allows us to be at our computers is over-identified in the United States as it is in Brazil with white people, right? So let's think about race, COVID-19, and the question of underdevelopment. The Guardian just yesterday published an article in the UK, which noted that Black Americans were dying of COVID-19 at 3 times the rate of white Americans. And Reverend Marshall Mitchell, who's the pastor of a church in a suburb of Pennsylvania, said that notwithstanding the fact that people have been saying, oh, the reason Black people are having such bad health outcomes when they get infected with the coronavirus is because of pre-existing conditions, high blood pressure, diabetes mellitus 2, and obesity. Marshall Mitchell says, no. America's pre-existing condition is racism, right? And we are seeing the fault lines of racism in real time as this epidemic plays out. My colleague, Professor Mallow Hudson of Columbia University, has pointed out that in the United States, where New York City is the epicenter of the pandemic, Latinx and Black populations are dying at disproportionate rates. But he pushes back against the idea that the reason for this is because Latino and Black people are more likely to have underlying comorbidities, conditions or comorbidities that lead to death as compared to other groups. He says, and obviously I think he's right, that we have to look at the ways in which social conditions and racial determinants negatively impact health and contribute to a maldistribution of underlying conditions, which makes certain populations more at risk of dying. 75% of all the frontline workers of people of color who work in public transit, in the grocery stores, in the convenience and drug stores, in trucking and warehouse and postal services and healthcare, as well as childcare in homeless shelters and family services in New York. 75% of those people are people of color. 60% of those people don't own their homes but rent. And on average, they have to spend 1.5 hours commuting on the subways, which have been shown to be vectors of infection to and from their work. And then when they get to their neighborhoods, their schools, their transportation, their access to food, their employment opportunities are all worse than those just a few blocks away on the Upper East Side, where the wealthiest New Yorkers live. So underlying conditions increase the risk of death of COVID-19, but it's not simply because of individual choice or individual conduct or individual profiles, but it's because our society has failed to develop and implement policy interventions that address the social, the structural, if you will, determinants of health and reduce inequities. This is an instance of underdevelopment, which American constitutional law and the theory of simply does not register and cannot remedy. Professor Evelyn Hammond, Harvard University, has put the point another way. She says, it's the social conditions that continue to produce these vulnerabilities in certain populations, not that the people are somehow inherently biologically different. Again, if you think about this in terms of the vulnerabilities that people have based on the social conditions that they live in communities with high density, they live in houses where there are lots of people living in small spaces. They do work where they're more exposed to something like the coronavirus. Makes you think of the situation of people who live in the favelas in Brazil. Those are the conditions that make people more vulnerable. It's not that their bodies are somehow inherently different. There are places in this country, in the United States, where whites, who are part of the larger population, do not want to invest in a public health infrastructure that would respond to the needs of the most vulnerable of their community. Now, I live right here in New York, in Harlem, which is in many ways the capital, the cultural capital of Black America. A few years after I moved to New York, the then Mayor Koch, deliberately pursued a policy of closing hospitals that were cited and provided clinical care, preventive prophylactic health care to the Black and brown people who were at that time a majority of the residents in Harlem. So most Black people, most brown people don't have health insurance. And their first point of contact with the healthcare system is not with the primary care physician, but with an emergency room, right? They go when they can no longer afford not to go. And by that time, right, their underlying state of health sets them up for worse outcomes. So these are issues, it seems to me, that can only be understood within the human rights development frame. And I'm reminded of an observation in the 19th century by Rudolf Virchow, the German doctor and epidemiologist who has been called the father of social medicine. He wrote that the very word public health shows those who were and still are of the opinion that medicine has nothing to do with politics, the magnitude of their error. Medicine is a social science, and politics is medicine on a large scale. So if we see this question of healthcare and the denial of access to healthcare in structural terms, and as an instance of structural racism, it seems to me that one of the things that the development frame allows us to see is the ways in which legal theorizing alone about these questions of racial injustice may be necessary, but it's not sufficient. We need to think the question of law together with the question of politics, or we need to think about the ways in which these legal framings are informed by and are a continuation of politics, racial politics, by other means. And we ought not be deceived by the colorblind language of liberal legalism, which under the guise of formality, under the guise of a focus on the procedures that the government has followed and whether the government has intentionally, purposefully, and deliberately disadvantaged social groups because of race. We ought not be deceived into thinking that that optic provides us with an adequate field of vision for understanding both the social conditions that Black and brown people are facing, not just in the US, but in Brazil, but the legal injustice, the role that the law plays in constructing and consolidating the relations of power that make that seem, that inequality seem beyond the purview of law, and thus normalizes a situation of racial injustice, naturalizes a situation of racial injustice, which is neither normal nor natural. If I had time, I would have gone on to talk about these questions of race, illiteracy, and underdevelopment, but that will have to wait for another day. All right. Thank you very much. I know I've gone on longer than I planned, but it's been my delight to talk to you.
Kendall, thank you very much. That's great. So we can have now 30 minutes or so of Q&A, questions and answers. Is that okay?
That's fine.
Okay. So people...
Excuse me there, Kachi. I should have said at the beginning that I am on this Zoom call or in this Zoom meeting largely because of the generosity shown to me many years ago by Professor Koziki and Dean Shueri when they invited me to come for a month to teach a jointly sponsored course of PUC Paraná and Federal Paraná. And I consider them colleagues and comrades in thinking critically about the law. And I count it both a privilege and an honor to have been invited to be part of this first seminar.
Thank you, Kendall, for your generosity. But I think the pleasure are us, not yours. And so Does anyone have a question? Please activate your video and your audio. And please, before putting your question, say your name and institution. Okay? Bruno, do you want to start? And then Thiago, Ostino. Bruno, go ahead.
Hi, Bruno.
It's been a while, but we would be meeting in July, but I think it won't happen.
No, it's not going to happen, Bruno.
It's a pity. But I would like to ask you about the role of constitutional law. So you were saying that we should bring maybe the vision from human rights, but I was reading something about the role of presidents during pandemics and problems regarding health issues. And I remember that Reagan denied the SIDA, the AIDS question, and this was a big problem regarding the LGBT community.
That's right.
It was seen as a health issue regarding only the gays in the beginning, but then he was proved wrong, and he was largely criticized by not considering, not addressing properly this issue. In the same regard, we have a president here in Brazil, and that's the reason of my question, that mimics in the worst way possible Trump. And Trump is denying largely the problem of COVID, and Bolsonaro is doing the same here. So my question is, what should be or what's the role of constitutional law and the limits to the power of presidents in this context? Because they can at least have a role to help people or to try to arrange public policies to at least fight. I don't like the expression war, but usually people use this expression. This problem. In Brazil, we believe that we are going to be one of the countries with the worst responses to this. Our only hope is SUS, the public health system that we have, that avoids this being worse than it's already been showing itself. But my question is that, so what's the role of the president, and if symbolically or in practical terms, could she or he be someone that could advance these policies, or even something that we discussed in the past, but the role of Obama regarding Russia. So we can have another question, but I don't want to take all the time here. It could be someone, and I remember that you have some criticism about Obama, that could advance some policies regarding that. Not health issues, but race.
Right. Well,
Kendall, please give me 1 minute, please, before. I'd like to point out that Justice Minister Luis Roberto Barroso is. So, Barroso, thank you for joining us.
It's great to know that. Judge Barroso is a friend of Columbia Law School. I think the last time we saw each other was during the conference that our Columbia Brazilian Students Organization organized last year. They do an annual conference, and they brought a delegation of judges and lawyers and professors from Brazil for a very enlightening day of discussion. So I'm honored to have you with us in this meeting, Judge Barroso. Bruno, this is what I would say in a nutshell. As you know, one of the things that I do is I'm interested in law and culture. So I've been talking today thus far principally about questions of the intersection of law and political economy, and the ways in which a shift from a focus on discrimination to a focus on development places these questions of American political economy as a racial formation, or as a site for the exercise and contestation of racial power at its very center. The question you've raised for me, however, implicates less the question of political economy and the Constitution, and more the question of the Constitution and political culture. Okay, so this is a shift from political economy to political culture. And here, the figure of the American president, who the Supreme Court famously said is the principal organ of the nation, right? The president quite literally embodies America in the same way that the English king was thought to embody the English body politic. And we talked about the king's two bodies. And so what we need to understand here is the question of political and constitutional meaning, right? And the ways in which in his, and I use that pronoun deliberately, in his very body, right? The president, in embodying the presidency, right, represents in every sense of that word, or claims to represent the American body politic, or some part of the American body politic, or more precisely, a particular vision of the American body politic, and who belongs to, right, and is a part of the American body politic. Mr. Reagan in the 80s, in waiting, I think it was 6 years before he even uttered the word AIDS, was signaling quite clearly that, in his view, the American body politic simply did not include Black and brown people. Similarly, Mr. Trump, in choosing what is incontrovertibly a quasi-genocidal policy in which certain bodies are thought to be disposable and expendable, right, is also advancing a vision of what the American body politic is and which bodies belong to it. Think of the famous image in the first edition of Thomas Hobbes' Leviathan, right? You have this figure of the king, and then in that figure you have the body of the citizens, right? Donald Trump, he's not really interested in democracy or citizenship at all, but to the extent that he is interested, Black and brown people don't figure, right? Because they're either criminals who chase their ancestries to shithole countries, murderers and rapists, or they're just a few generations removed from being murderers and rapists. The real America, the America of his right-wing, anti-liberal, ethno-cultural nationalism, the real America are the white people who live in the red states that voted for him, who are showing up with guns to contest the authority which has historically belonged to state and local governments to exercise what we call in American constitutional law the general police power. That is to say, the power that state and local governments have as governments to enact and to administer policies to protect the health, the safety, and the welfare of the people in their states. Right? The horror for me, and this is what distinguishes Reagan from Trump from Reagan, and makes his regime truly a deviation from a constitutional order that even Reagan would have accepted, is this idea of a kind of social Darwinism translated into the political structure of our federalist system, right? Of divided government between state and local, the national and state and local governments. The states have been left to themselves. He sees everything as a kind of, in the image of a firm, in which the states are competing in a market for scarce resources, gowns, ventilators, masks, income support, and the like. And he is indifferent, right? And the reason I think we have to move, and this goes to the normative question, one reason I think we need to move theoretically to an understanding of the human rights and development question is because what we are living through in the United States is a rejection of the very idea of law as the architecture of American politics and policy, right? Trump is practicing a kind of biopolitics, right? Of the kind that Michel Foucault talks about, and that Giorgio Agamben, in a slightly different way, talks about, in which the bare lives of people who were formerly figured as citizens are deemed expendable or not. So it's truly a question of certain bodies not recognized as citizens, right, being expendable, right? Now, of course, the irony is that many of the people who are going to die because of this single-minded and very cynical pursuit by Mr. Trump of reopening the country prematurely against the advice of almost all the nation's public health establishment, is that many of these people who've been out in the streets without masks protesting are going to get sick and die in the red states. And in fact, if you look at the pandemic as it's now unfolding, the number of cases in the red states is increasing. So I haven't even gotten to the question of the economic immiseration, which is a pandemic of its own, which is going to last really much longer than the actual pandemic itself. But there's a sense in which we are living in a new order of biopolitics, in which the claims of citizenship, in which the understanding that norms of governance with respect to the relationship between the national government and the state government imposes a responsibility under the Commerce Clause of our Constitution and under the necessary and proper clause of our Constitution, for the federal government to step in to deal with social issues or economic issues or health issues that the states, either by themselves or together, are incapable of dealing or incompetent to deal with. That baseline understanding, which was the narrative, right, the constitutional narrative that I was raised in as a young law student, and has been the constitutional paradigm within which I have operated throughout my entire career, it is unraveling. And so what we're seeing is the emergence of a kind of viral political order, which has infected, right? As a consequence of two things, racism and greed, which has affected the American idea, right? That is reflected in our Constitution, that the federal government has a specific and unique responsibility, right, to mobilize its superior resources to address issues that no state or local government left on its own can deal with. And so what we're dealing with actually is, the afterlife of neoliberalism, understood not just as an economic order, but as a mode of political economy, which has infected through its market fundamentalist contagion the very vision and practice of constitutional politics, right? So that, and what Trump has done, I mean, there's been a lot of talk about how Trump is not a neoliberal, tariffs and all that, and, involvement by the state in the economy is not neoliberal. He's an authoritarian populist. But I think what we could say is that Trump may not be a classic neoliberal, but he very much is invested in the kind of cost-benefit analysis with which neoliberalism, as practiced in the legal academy by the Chicago and school lawyer economists, right, is a part. But he's put a particular twist on it, which is the reintroduction of what I can only see as a kind of social Darwinist logic. And that's a sense in which, Trump is a constitutional regression. He's taking us back to a political moment in which cooperative federalism between the state and national government was thought to be the norm of the modern period. He represents, through a kind of the political equivalent of a kind of social Darwinism, in which the states are fighting and competing with each other and with other states. He represents a kind of political regression and an erasure because of, again, racism and greed and his own outsized megalomaniacal temperament. A regression which I think is truly frightening, and which is the face, the distinctly American face of a kind of neo-fascism. And I think, I don't have a problem. Many of my colleagues are too polite to use that phrase, but I don't have a problem calling this a kind of neo-fascist anti-constitutionalism, in which he claims to embody in his very person, right, the law, right? He says, I'm the president, and the Constitution says I can do whatever I want to do. I'm quoting him here. I can do whatever I want to do, right? You know, that comes perilously close to the notion that the Führer's word is the law, right? And to a kind of exceptionism, right? That Carl Schmitt theorized. So we're talking constitutional or legal theory, but I think, you know, we have to be prepared for the possibility that the conversation that we're having is about an emerging paradigm, which is post-legal, or at least post-legal in any sense with which we have until now understood the term law and the notion of legality.
Okay, before Tiago, I'd like to just say that I think the same is here in Brazil and with Bolsonaro, but I think Bolsonaro is even worse, Kendall. And I'm gonna one step further and calling it not only biopolitics, but necropolitics.
Yes.
I think it's happening now in Brazil, in the United States, and other places of the world.
Yes, and that's the phrase I've been using. I've been writing on my Facebook that, you know, the national government of the United States has now become a death state.
Yeah.
Right? What you see is power over life and death. That's biopolitics. There's power over life and death, but where the balance is tipped in favor of death, right? Right. When he says we've done an outstanding job, we've been successful, right? When Mr. Kushner, his son-in-law, says, you know, this has been a great success. Yes, it's been a great success in making the United States number one in the incidence of death as a result of this virus, and Brazil seems to be catching up. Right? I read that it's now number 3 after the US and Russia on the list of cases. I don't know where it is in terms of deaths, but the way things are playing out, given that, you know, you're even worse off in terms of your healthcare system in many ways than we are. You know, it breaks my heart because, you know, I am, or like to think of myself as a brasileiro da coração, and to watch from a distance this totally avoidable decimation of the Brazilian population. You know, I was talking a few weeks ago to a group of students and activists in a seminar that's been organized at FGV Rio. And the young man who organized it was an exchange student at Columbia, who's from one of the comunidades in Niterói. You know, it's when people don't even have access to soap and running water, plumbing, no possibility of social distancing. I think you're right that it is a kind of thanatopolitics, right? A necropolitics in which the state is seen, in the words of a book that I read many years ago, as a kind of ideological weapon of death, right? And that's the, you know, that's the, right? And I mean, people have said, you know, Donald Trump has declared war on his own citizenry. And I think that's certainly true of Bolsonaro when he says, so what? What do you want me to do about it, right? People are going to die, right? Yeah.
Tiago, and then Rafael and Vera, and maybe we should call it a day.
Okay.
Vera.
All right.
Tiago.
Tiago.
Good evening, everyone. Hi, Kendall.
Hi, how are you?
I'm fine. I'm happy to hear that you're fine too, facing all that.
We were in touch. Tiago was a great help to me a huge help to me in thinking about how I was going to spiritually deal with this experience.
We say somehow there is also a kind of spiritual warfare.
Yeah.
Right? Since you were a Brazilian in heart, I would say more than the heart now these days, I'm wearing this in honor to you, Basquiat.
Okay.
Tonight, but I won't take much of your time. I'd like to comment briefly on 3 points of your lecture. Thanks for that. Brilliant as always. The first one is about the framework you've mentioned, or the distinctions between diversity and compensation framework.
Right.
In what concerns affirmative actions,
right,
or politics, right? I feel we are somehow facing the same dilemma, which we thought was overcome already in Brazil, because affirmative actions have in Brazil, at least for university access to education at university level, a time standard or a revision period, which is coming to its first stage of 10 years in the next 2 years. So federal government has started calling researchers to evaluate the efficacy of these politics, as we probably will see, with the intention to reduce the percentage of reservation queues, right? So that's one point I think is very interesting, because thinking of diversity as a public good or a principle of education and not compensation that is supposed to have an end, since it's done, we compensate those people affected, is very interesting and not yet totally, I feel, popularized in Brazil in the comprehension of how those affirmative actions work in universities, at least. The second point, how the last part of what you were saying of your lecture concerns, I believe, what Butler calls the uneven or unequal distribution of precariousness, right? Precariousness among bodies. And now it's even more explicit with COVID. But using specifically this point, or starting from that, I'd like to hear you a bit on this. I mean, since conditions and precariousness are unequally distributed among territories and bodies, don't you believe the same paradox Butler and Athanasiou see in dispossession is also working here with development? What I'm trying to say is development usually assumes a drastic or dramatic reorganization of territory and of people. Development, or the usage of environmental resources. And there might be, in the protection of diversity, a certain right to not development, or a right to stop or to diminish the rhythm of development. Also being somehow denounced by racial injustice and environmental justice movements. Term development also always has impacts, and those impacts are unevenly distributed as well, right? So I'd like to hear you on that point. Do you think it is possible to reach somehow a balance or a just measure between diversity and development, considering the uneven distribution of precariousness, especially with gender and racial emphasis? Thank you.
So if I understand you correctly, you want to suggest that you want to embrace or advance a more positive and benign conception of diversity than I do. Is that right? There's some affirmative, positive understandings and deployments of the idea of diversity that my kind of relentless focus on the limits of diversity and its association, the genealogy of diversity, as an alibi or diversion overlooks. And I think, what I would want to say would be less about diversity than about your conception of development, right? Because what I hear you saying is that there's something like an identification with, or something like a constitutive connection between development and capitalism, right? I think, if we embrace, for example, Sen's capabilities approach, we don't need to say, right, that, economic development has to be so-called, since it's never really existed, free market capitalism or market capitalism, right? The right to development doesn't stand in isolation, and this would be the second point. That would be the first point. The second point, it would be that I make that first point because about development not being a synonym for free market capitalism, right? Because in the human rights framework, human rights are connected and arguably even indivisible. And at the human rights level, this is in my PowerPoint. At the human rights level, development and obstacles to it, Article 6 of the Declaration on the Right to Development says, can result from a failure to observe civil and political rights, as well as economic, social, and cultural rights. Article 5 mentions the fundamental right of peoples to self-determination, right? And so the right to self-determination, it seems to me, is closely associated with the right to development and the right to choose what kind of development or what development will look like. And so it's not the IMF or the World Bank dictating, right, what development means and what, operationally would look like. It's recognizing the right of people to decide, and this is true even at the national level, right? What their schools will look like, right? Whether, and these are all, I was going to talk about the question of illiteracy, which is a huge problem we're facing here. And there have been some cases brought under the Constitution here in the United States claiming that, the state of public education in this country that most Black and brown kids have, where they're, hyper segregated and under-resourced, violates the right to literacy. But, the claim is not we should be allowed to go to school with white kids. Maybe we want our own schools staffed by Black and Latino teachers, right? So this right of self-determination is important. Katya, with your indulgence, I'd like to offer an opportunity, if I can, for one final quick question. Is that a possibility? Or we run over time?
Yes. Actually, we have 3 people wanting to ask you something, but okay.
Can we
so
among
May I make a suggestion? Just take the 3 questions and Kendall, you just answer.
All right.
Gives
All right.
all.
Yes.
Okay.
Okay. Next.
So, Vera, Rafael, and Sergio, please be quick. 2 or 3 minutes.
Actually, I just would like to thank Kendall for this amazing opportunity to be again with us. And now, what I was going to ask you somehow answer to Thiago is about the performative of the word diversity and development. Once you say development, it seems to me that you are of liberal legalism. So we have maybe we have to get in touch with this new grammar for rights, and in order to understand that what you mean by development instead of diversity. That's all. Thank you very much.
Okay, I didn't understand. You said in the grammar of liberal what? Liberal
Legalism.
Legalism. So you think that development is internal to the discourse of liberal legalism?
I do.
Well, that's a conversation that we need to have, because I think certainly in the American context, that language is utterly foreign to our constitutional discourse, because we do not recognize economic and social rights as constitutional rights, right? In the United States, constitutional rights are limited to political and civil rights, and they're the rights of individuals. So the notion of development has any traction, it's under it's within the narrative of, you know, individual flourishing. That's a phrase one often hears, right? It's personal to me as an individual, and it is my right to forge. I mean, there are even Supreme Court cases which use this language to forge my own meaning. So it's kind of a laissez-faire approach, and not the development approach, which seems to me to focus on collectivities, on the social basis of our collective lives. So that's what I would say.
Thank you.
Okay. Yeah.
How far? 1 or 2 minutes.
Okay, thank you, Professor Kendall, for this great conference. I am Rafael Kirchhoff. I'm from the ANAJUD. I have sent you an email recently because you have agreed to be part of our association as a member of the advisory board. So thank you also for that.
Sure.
My question is about LGBTI rights. So we have had a lot of cases in the Supreme Court regarding to the marriage, regarding to the right of changing the documents by trans people, and recently the right of inclusion in educational for LGBTI and women, and also the case related to the prohibition of blood donation by men who have sex with other men. The Supreme Court has declared unconstitutional this prohibition, and also in the first case a prohibition of city law about the gender ideology. I don't know if you are aware of this type of concept, but this is very common in Brazil. Most of our conquers rights of LGBT rights in Brazil have come from the Supreme Court. So as an activist, I would like to ask you how it's possible to set as real conquerors if they don't come from the Congress. Is it possible to think about this difference, or we can assume that as a conqueror, as an activist? I'm not a scholar, but I am from this place.
Right. Well, to the extent that Brazil sees itself, its legal culture, as rising of liberal democratic constitutionalism, right? Courts are political, and here, I drop a footnote to Ronald Dworkin, say the legitimacy of the Supreme Federal Tribunal, like that, say, of the Constitutional Court in South Africa, right? As a court, as a young court, right? Which is exercising the role that the judiciary in liberal democratic constitutional countries has traditionally exercised to sort of build and elaborate a culture of democratic rights, is doing important work. For me, as an activist, not as a lawyer, but as a political and LGBT activist, the question is, what do you do with those decisions, right? And how do you leverage those decisions to do the very important cultural work of educating the Brazilian public, to build a consensus around these legal rulings, which is cultural, right? Particularly in the face of the assault on the very idea of equality of sexual minorities, and for that matter, women, right? That is embedded in this, this declaration of war against gender ideology, a term, by the way, which means everything and nothing, right? So I think it's important to recognize that judicial decisions are tools, dare I say, even weapons, right? To be used in ongoing culture wars, because there's definitely a culture war going on in Brazil. And culture, contrary to the views of some on the left and liberals, culture is not inconsequential. And I think I'd love to be part of conversations about the kinds of cultural work or the kinds of activism, the uses of the media, right? In particular, social media and other platforms, what kinds of activism are necessary, not just to amplify, but to consolidate this counter discourse, this discourse, which I think can be used to contest what, from my point of view, is an effort to stage a kind of counter revolution in Brazil, to de-democratize Brazil. I mean, it's important never to lose sight of the fact that, these attacks on the court trial to
Tem microfone aberto, por favor.
Yeah. These calls for a return to military rule, right, and a permanent state of martial law, in effect, right? I think ought to leave no doubt of the role that cultural contestation is necessarily going to have to play in winning the hearts and minds of people who are persuadable. Sergio.
Sergio, the last one, please.
Hi, Kendall. It's always good to hear your thoughts and to learn from you. It has been a pleasure for more than 10 years from friendship. And so my question is about the role of the Supreme Court in face of the actual threats of democracy. I think you correctly assess the situation in either in Brazil or in the US about our presidents and their threat. You mentioned like very strong words such as neo-fascism, or ideology towards death, or mentioned something like that. And my question is always about like what would be the role of the Supreme Courts and in terms of upholding the Constitution or upholding democracy, and not only in terms of to fight against like concrete laws or concrete actions from the government, but also from grossly neglecting situations, or grossly mistakes or this kind of thing done by the executive branch.
Mm-hmm. That's a great question. My friend, the political theorist Wendy Brown, wrote something many years ago that I've carried with me, and which helps me think about, how to what is to be done right now, because I think we are in a position, we are in a state right now in the United States, and arguably in Brazil, where it's not clear to me, whether we're not going to be in a position where, well, we're not going to find ourselves in a situation where we're fighting well, let me put it this way. It's not clear to me, a la Gramsci, whether the moment that we're in calls for a war of position or a war of maneuver, right? I'm genuinely perplexed. And, as a radical constitutionalist, I really don't know. It's really hard to sort of read this moment in some ways. But what Wendy Brown says is that the left, and I want to identify myself as a member of the left, I hope nobody's offended, not a liberal, right? But as a member of the left, there are moments in which leftists have to defend liberalism, insofar as liberalism provides the conditions of possibility for more progressive constitutional politics, right? And one of the things that seems to me that is under attack, both in Brazil and in the U.S., and these attacks, the face of these attacks may be Mr. Bolsonaro and Mr. Trump, but I had an experience which I've told you about, Sergio, when I gave the keynote to the Sao Paulo Bar Association a couple of years ago, that they organized to celebrate the anniversary of the Universal Declaration of Human Rights. There were lawyers saying to me things like, well, rights belong to people who deserve to have rights, right? And so we're at a moment in which the basic idea of the rule of law, the liberal idea of the rule of law, is under stress. Indeed, it's not just under stress, it's under attack, right? And so I think the role of the courts as the institutional guardian of the very idea of the rule of law the historical situation, however, in the two countries is very different, because in Brazil, we have an old, I mean, in the US, we have an old court, right? But the right wing has played a really smart, long game in which, you know, they have been appointing judges who are willing to reach the results that they want the courts to reach, and to use the forms of law, right, while doing it, right? They are weaponizing the law, right, in an assault on the rule of law. That's what makes liberal democracy so vulnerable, right? Because the very thing that is at the center of the idea of the rule of law is a thing that can be used, you know, to infect it and kill it from within. That's part of, so the necropolitics that Professor Kozicki was talking about is not just of bodies, but about the death of law, the potential death of law. And I'm wondering, you know, whether, you know, if we have another 4 years of Trump, the very idea of the rule of law is going to be, the rule of law as an aspiration. I don't want to claim that we've ever lived it, really, or realized it, but as an aspiration, it's going to be on life support. By contrast, in the Brazilian context, because Brazil is still a relatively young democracy, I made this point to you and to others, observing the Supreme Federal Tribunal, it seems like it's a court in search of its identity, right? A court in search of a method that would institutionalize it as a court, right? In a way that would give it the legitimacy and the authority to be the voice of the Brazilian Constitution, or at least of that aspect of the voice of the Brazilian Constitution, which is rooted in a normative commitment to the rule of law, right? So as lawyers, I think your responsibility as Brazilians who are lawyers, but who are also citizens, right? Even if you're leftists, is to work in coalition with liberals to defend the rule of law, right? And again, I don't know whether that's a war of maneuver or a war of position. I don't think it's a war of maneuver, but you might have to go on strike as law to defend the rule of law, right? Students might have to walk out of law schools and into the streets. Law professors might have to walk out of law schools and into the streets to defend the rule of law as something without which, you know, the very condition of possibility of democratic self-governance and of democratic justice will be at risk. So, you know, I think that you know, I don't know whether this is an infiltration of the Supreme Federal Tribunal or of the Brazilian state, right? We speak for the judges, right? We ally ourselves with the judges, or whether it's an assault on the vision of a state in which you know, the president or the executive can disregard the rule of law. I don't know. But that it seems to me is what fundamentally is at stake in this moment. And you all are going to have to decide among yourself. The problem is that, you know, you have someone like Judge Morrow, who has been lionized, right? in Brazilian culture for his anti-corruption campaign, but who has not been, it seems to me, sufficiently interrogated and criticized for the ways in which he created the conditions of possibility for the emergence of a Bolsonaro. And I mean that not just politically, but in terms of his conduct as a judge, right? Who was willing to bend the rule of law in order to achieve a politically expedient result. Now, I don't, I'm not a citizen of Brazil. I may not be allowed to come back in the country when travel resumes. But it's a complicated picture, and so you've got to think politically about these questions of defending the rule of law, both as an idea and defending the institutions that are both the institutional and the imaginary, right? Instantiation, right, of a society governed by the rule of law. Now, there may be rule of law skeptics on the call who are shocked that I call myself a leftist and am defending this defense of the rule of law, but no less a leftist than Wendy Brown says that there are moments, historical moments, when we have to realize that our chance of making the society more just requires us to defend liberalism when it's under attack.
Kendall, thank you very, very much.
Thank you.
A great discussion, but if you sing a song for us, just a short one, it would be perfect. But if you are not willing to, okay. But I remember the end of the high school.
I cannot deny you. Katia knows that I can't deny her anything.
Okay.
Because when I was in Curitiba, her mother made for Sunday lunch, at Katia's urging, the most delicious feijoada. Now, I've sworn off feijoada because I think we all need to be vegans at this moment, or at least as close to veganism as we can be. But I will sing a song for you nonetheless. All right, so this is just a chorus of one of the great anthems of the African American Civil Rights Movement. Just a chorus. And it's a word of hope too. We shall overcome. We shall overcome. Shall overcome someday. Deep in my heart, I do believe we shall overcome someday. We shall all be free. We shall all be free. We shall all be free someday. Oh, deep in my heart, I do believe that we shall overcome That ought to be good for moqueca or what's the other dish? The wonderful cod dish, Gomez G. What's the name of that?
Gomes de
Bacalhau.
bacalhau.
Nossa.
Yeah.
Bacalhau.
Or moqueca, and Vera can make the pirão.
Okay. I remember. You did the pirão.
Yeah, but you told me you make a very good one. So
We had a great time at your place.
yes, we did.
Thank you. Oh, sorry.
No, what were you going to say?
Thank you.
Thank you.
Thank
Thank
you.
you. Thank you. It's so great to see your faces. It hardens me, and I Guilherme. Hey,
Professor.
Bye, Kendall. Thank you very much.
thank you. So let's stay in touch, and I'm delighted to have had the chance to do this. You will let me know what your next event's going to be, and I'd love to participate.
Kendall, you remember that we were going to have that huge conference on Black researchers.
Yes.
So I'm not sure if it's gonna happen, but
That was,
Paul is in touch with you, right?
yeah.
Okay.
You know, lots of things are moving to virtual. The Law and Society meeting this year is going to be a virtual conference.
Okay.
So if you have the right license, you can get a lot of people on this platform.
Yeah.
And I think, you know, over time, use this as a way of being together and of intellectual exchange. You know, just coming to really see the possibilities that it presents as a technology, you know, for bringing somebody who's in Curitiba into a classroom in New York or vice versa. So I'll look forward to working with you toward that. Thank you all again so very much. This was wonderful. Okay.
Bye-bye.
Beijo.
Bye.
Ciao.
Thank you.
Ciao, ciao.
Thank you.
My pleasure. Bye.
Bye.